Good afternoon and welcome to this meeting of the Family Law Subcommittee of the California Paraprofessional Program Working Group. I'd like to go ahead and start with taking roll. Bashan, Hamilton, I'm going to actually just make sure there isn't anyone. Yeah, there's nobody in the waiting room. Bashan, Hamilton, McRae.
Here.
Olvera.
Here.
Sarush.
Here.
Judge Wiley.
Here.
Thank you. So I don't have any slides. Just to give an update, what we're left to do with this working group is to develop recommendations in the violence prevention, and then with regard to adoption and the child welfare issues, the pre-filing. And I want to thank Dana for providing this, the build out of the tasks for the child welfare cases. And in terms of the other tasks, I think that Elizabeth, you were going to work on the uncontested or the step parent adoptions.
Yeah, I have that. I'm just putting the final touches on it, but I'll be ready to share my screen or forward it to you after the presentation from Dana.
Okay, that'd be great. And then Stephen Hamilton recommended that we get in touch with, can't remember the name, but somebody who's very involved in adoptions, and I've reached out to him and haven't heard back yet. And in terms of the violence prevention, we also have reached out to a couple of different people, and we're working on getting that. Hopefully I'll have, for the next meeting, I'll have some more information. But so maybe for today, and again, I don't see any attendees, so I don't think we need to do a call for public comment. But for today, perhaps what we can do is start by looking at what Dana sent. And Dana, maybe you can tell us a little bit more about your conversation with Ruby and her thoughts on paraprofessionals being involved in these pre-filing child welfare matters.
Before we start with that, I have a question about the violence prevention tasks work. Are we including domestic violence restraining orders in that, or is it for non-domestic violence types of violence prevention orders?
The non-domestic violence.
Okay.
Because domestic violence has been covered in the family law.
Okay. So I think maybe we should kind of make that distinction.
Yes, yes. Thank you. So do you want me to, I can go ahead and share the screen that shows what you had sent.
Yeah, that would be good.
Okay, can you see that now?
Yes, great. Okay, so it's been more than a minute since I did any work in dependency court. But when I was the Santa Cruz County Council, I hired Ruby Marquez to come over and represent the agency. And she had previously been with Lacey, Legal Advocates for Children and Youth. So she's a dependency expert, and she was my secret weapon here. She's also very recently been appointed by the legislature to the Closing the Justice Gap Committee. So she knows what we're trying to accomplish here. And this is just a quick summary of my conversation with her. The short way of saying this is everything that happens to support a family who's been told that there's been an allegation of abuse or neglect up until the first court appearance and appointment of counsel. Those tasks would be appropriate for a paraprofessional. So there are things like requesting the investigative narrative. So what did the initial caller say? Advising the parent to cooperate with the investigation, because so often you can avoid a filing if you simply cooperate. Ask for something like a CFT meeting, where you can bring a support person and be in a room and find out what services are available, what are the issues that brought the family before to the attention of the agency. in that CFT meeting, or even without it, you can identify a support network, people who you could safely leave your child with if you're feeling like you need some time away. The paraprofessional could assist in gathering all kinds of documents that would be helpful to the agency as they make their decision about the investigation. It would be helpful for a paraprofessional in dependency to keep a current list of resources for families, like drug and alcohol testing, where you can go for services. And then the agency well, I don't know how many counties do this, but certainly in the bigger counties, and Santa Cruz has had it for many years, parent mentors or parent advocates. And these are parents who successfully went through dependency, came out the other end. They didn't all reunify, but they have a unique perspective, and they can be matched up with a family and given assistance as they go through this. Certainly negotiating voluntary agreements. Some counties call them voluntary agreements, others call them informal supervision or being evaluated out. So a call comes in, the agency says it doesn't rise to the level. So we're going to either enter into a voluntary agreement, which gives families free services. We're going to refer it out with, evaluate it out with referrals for free services. The catch here is that sometimes if the family doesn't take advantage of the services that are offered, the agency will go back and file a petition. So here it would be really valuable to have a paraprofessional make sure that the family knew where to go for the services, made sure they were documented, and navigated what can be a complicated service referral process. And then, of course, as Fariba has mentioned many times, the JV 180. So after a dependency is dismissed, if it gets filed and then it's, winds its way through, it gets dismissed, there are very often, there are needs to get those exit orders adjusted. Often visitation, grandparents want more, or one of the parents wants more if it's a guardianship, things like that. Some counties do it on the dependency calendar and others send it over to family court. And it's a form, and I think most of us have talked about feeling like that was appropriate for a paraprofessional. And then as I poked around with other things, I noticed in the IHSS regulations, and I only bring this up because I know Stephen has mentioned more than once this notion of representative, calling a paraprofessional a representative or allowing them to represent. Here's an example. In the CDSS regulations regarding IHSS, people are allowed to bring in a quote authorized representative who is a non-lawyer and participate in these appeal hearings when a consumer of IHSS services wants more services, different services, or has been denied services altogether. And there's a form, and I've attached it here. So I only do that by way of, we should be careful. I think when we're talking about we can't do this and we can't do that, because there are examples in the law that we may not know about where non-lawyers are allowed to attend, participate, and quote, represent.
Okay, and I think that I don't remember, Linda, is the IHSS, is that on our administrative agency? I don't know if that's one of the hearings that we specifically identified under the administrative agency processes where non-lawyers are allowed to represent.
I don't think that it was.
In-home supportive services, okay.
Yeah.
Can you scroll up, Linda?
Yes. Sorry.
Any discussion, questions? Is there agreement that these would all be things that a paraprofessional would be allowed to do?
I just wanted to add that we found out recently another use for JV 180 that I think paraprofessionals could also help with, that sometimes guardianships are issued in a juvenile dependency case, and to terminate those, JV 180 is used. So that's another use. And as for everything else, I think that this is exactly what these paraprofessionals can help parents do, because it's really hard to navigate that. on your own. And these parents are some of the worst moments in their lives. They're very traumatized and they cannot focus on even the simplest instructions. So it would be great to have a paraprofessional who is not in that state of trauma to kind of hear the instructions. They know the instructions, they know what to do, and to help these parents out. So I would totally agree that all of this is appropriate.
I agree. I think that focusing on before the petition is being filed and then after the petition has jurisdiction been terminated or dismissed, I think that's key for the dependency process, because once the petition has been filed and they're actually in reunification or, whatever part of the process they're in, they have representation by attorneys, and they will, after dismissal, termination of jurisdiction, they'll have the right to appeal, and those attorneys will provide that representation. But it's kind of the areas before the petition's filed and then after everyone's done that I agree are the two most important parts that someone else can and should come in and provide some assistance. So I agree with the list. I don't think I have anything to add.
I agree with the list as well. I think that this is a good list. This is a good place for paraprofessionals to really help parents who are going through trauma. I'm just wondering, where are the referral points, especially if this is the before point, to make sure that parents do connect up with paraprofessionals and know about these resources, especially if they're overwhelmed and there's a lot going on.
Well, self-help centers for sure. I mean, we see people referred here. I wonder if this would require probably some cooperation, but at the first contact between social services and the parents, maybe it could be, I don't know at this point whether they hand out any resources to parents, information about First 5, any kind of pamphlet or anything, but this may be included that assistance is available through paraprofessionals. Again, I think it's another agency, so it requires some collaborative work.
Absolutely.
I agree. And anecdotally, there are a lot of cases that don't make it through the dependency process, that a petition is not filed. They're placed in different triaging programs before a petition's filed. So I think it's kind of important at that point, if there are service linkages that can happen, then I agree that we would need some cooperation with that. But I think that would actually probably improve outcomes.
Well, certainly at a minimum, as part of the overall outreach plan for the paraprofessional program, we could include outreaching to the 58 county heads of social services agencies to say, we're licensing a new class of licensees. This is one of their authorized scopes, and we request that you provide that information. So we could include that in the outreach plan. Anybody have anything else on this?
Stephen, do you want to weigh in?
I think these seem like all reasonable activities for the paraprofessional to do. The one that I'm concerned about is number 2, advising a parent to cooperate with the investigation, because that implies they could tell a parent not to cooperate. And there are investigations that can lead to criminal prosecution. So there's potential Fifth Amendment privileges applied. That's the one that caught my eye, that would potentially go beyond the scope of what we'd want paraprofessionals to do, because we're not allowing them in criminal law to advise people to waive their Fifth Amendment privileges, correct? We're only doing collateral criminal.
I knew when I used the word advise, it would catch your eye. How about we just change that to assist parents during the investigation?
Yes. And really it was the cooperate that caught my eye, because like I said, if they're telling them don't cooperate, then I am concerned about the Fifth Amendment privileges that could be waived if they tell somebody to cooperate and they give evidence and then a criminal prosecution comes.
Is there, so I'm assuming that there's be some sort of training, or the curriculum for their training will include this, right? This work.
Yes.
And so they'll be learning about the process, about this process, learning so that they can explain the process to their future clients who come to them with these issues, right?
I would assume so, because dependency is so time specific. Depending on the age of the child at the removal, you have a very, very limited amount of time to potentially cooperate with reunification services. So there would need to be, I think, significant education with respect to this particular issue. You're muted. Karima, you're muted.
So that I would hope that one of the items here would be that they explain the process and the deadlines to their client. And so maybe
I was going to say that should be number one, but I agree. There has to be some significant education, because unfortunately, there are some significant deadlines that the parents do need to know about before you get to a period of time where you might be looking at a 2-6 hearing or something of that nature.
Mm-hmm. That could mean the difference between having a petition filed or not, right? If they do everything successfully and they meet all the deadlines and do what they need to do.
Exactly.
Anything else on this one? Okay.
Great. So this is great. So I can incorporate this into the recommendation that we bring forward at the February meeting. And Elizabeth, are you ready to share your adoption list, or are you still working on that?
Yes, I can share it. But before I do, let me just say that I don't do adoptions. So this is just me as just a lay person trying to get information about adoptions and then present it to you guys about it. But I did talk to Helen Bellamy, who does adoptions, and we talked about the different tasks and that are involved. And so let me just share my screen with that. And if anyone does adoptions and needs to correct me, please do so.
I did 8 this morning, but so let's see what your list looks like.
Sounds good. Let me see.
Wow.
Screen sharing capabilities.
You
Can you guys hear me?
Yes.
Yes.
Okay, perfect. So again, this was based on a conversation that I had with Helen Bellamy, and she's actually working with the county sometimes to prepare some of these documents. But just a quick background, there's 3 kinds of adoptions. There's the independent adoption, where there's no adoption agency or the Department of Social Services is part of it. In these cases, if the existing and adopting parents agree, the parental rights don't have to be terminated. Independent adoptions can also include the Indian Child Welfare Act when you're adopting an Indian child, sometimes referred to as a tribal customary adoption. And that's written in the family law code, more information. The second type of adoption is the agency adoption. That's when the Department of Social Services or a licensed adoption agency is part of the process. Like sometimes kids are in juvenile proceedings, maybe they're wards of the court, and that would be an example of an agency adoption. And finally, the international adoption, when the child is to be adopted was born in another country. So I believe that we're limiting our task list based on just independent adoptions, since they're the most simplest and more common one.
Elizabeth, can you make this a little bit,
Yes.
Can you zoom this so it's a little bit bigger? Thank you. That's great.
Thank you. And then this information was taken from the california.courts.ca.gov. If any of our attendees want to look more deep into that. Okay, so generally the tasks that the paraprofessional or existing LDAs are doing now are, they are drafting the petition for adoption. There's actually a form called adopt-050, I believe, that info that has a step-by-step breakdown of what the adoption process is. And so, and then also the forms referenced are there. But pretty much the person filling out this paperwork, whether it's a self-represented litigant or some third-party assistance, they're drafting the petition for adoption. They're gathering supporting information that will be helpful, such as helping people get copies of recent birth certificates or lost birth certificates, helping people obtain the marriage license. Very important in a step-parent adoption because, you know, I believe that how you file will depend if the step-parents are married at the time of filing. Also, they can file the paperwork at the court, help the parties get a case number. Those cases are not necessarily publicly available to the general public. Once the paperwork is prepared, it is sent to social services agency. The paraprofessionals can help the customers send the correspondence necessary to the social service agency with additional information such as the name of the other birth parent, maybe the whereabouts of the other birth parent, to assist social services with obtaining consent for this adoption. Once social services reviews that information, they work on getting a consent and they prepare a report that is filed with the court. Once that report is filed, then a hearing needs to be scheduled for determination. It's my understanding. Determination one, whether parental rights need to be terminated, and also to issue an adoption order. And please correct me if I'm wrong or if I skipped a step. Okay. Social services gets the consent necessary. They file a report with the court. There is a third-party investigation. The customer gets a copy of the report. And then how the paraprofessional can help is finalize the paperwork to schedule a hearing for determination, draft the adoption order, draft the adoption agreement, draft an adoption expense list, file paperwork with the court, get a court date, send parents to hearing. Usually they go unrepresented. Some of the hearings are in chambers. It's informal. It's not open to the public. Family sometimes comes to these. The process from beginning to end, just estimate around 1 year. And then reasons to allow it. I mean, LDAs are already doing it, and there is some independent oversight with the social services agency. And then here's just some where I got the information from. Is there any corrections or anything that, regarding this? No. Okay. So with that, I leave you guys with that.
So just in general, I agree with most of the steps. I haven't had a chance to look at them, very carefully, but I do agree that you've captured, I think the majority of the steps. The only thing that I don't see is once in a while, we will have to have a citation hearing for a parent. And that actually may be something that certainly the paperwork for the OSC, the citation hearing notice, et cetera, is something that the paraprofessional would be able to also assist the client with.
What is that hearing, Judge Riley?
So there are times when you know the other parent, but there's an issue of abandonment. There's an issue of the other parent. You've attempted to get a consent for an adoption, but the other parent does not, wish to, for one reason or another, consent to the adoption. So you would file an OSC, and another parent would be provided notice for that proceeding. They could either come, and I've had sometimes parents who have come, and it's essentially, why shouldn't my rights be terminated? Or why should my rights be terminated? And so it's an evidentiary hearing. I've appointed counsel for the parent. If the abandoning parent does not have financial means to hire an attorney to represent them. They will then, essentially will have an evidentiary hearing with respect to whether or not parental rights should be terminated in that situation. It's very rare. I think I've had 2 of those types of proceedings in 8 years, but it sometimes does happen.
Can I ask if it happens like even in a step parent adoption, if the other parent isn't deceased? Like, I'm just trying to think of the circumstance, not in a dependency, situation, but where there would be somebody objecting to the adoption, or somebody is,
It's contested. In that situation, so the biological parent, their parental rights have to be terminated before the step parent adoption can occur. It's a separate, not even a parallel proceeding. It has to be done first. And I know our court appoints counsel for the parent whose parental rights are going to be terminated. I think that's uniform throughout the state, isn't it?
Correct.
Yeah. So that's what happens there. So they would already have counsel. At least the parents whose rights going to be terminated would have a right to appointed counsel.
okay. Because we had been talking about, I think we're talking right now about step parent adoption specifically. I think I'm a little unclear about what on the adoption continuum we're talking about.
So it is a step parent adoption let's say there's a biological father who has
Mhm.
not been involved in the child's life, and mother has gone and remarried, and now new father would like to adopt the child. So the biological father would then have to his parental rights would then have to be terminated, or he would have to show cause why they should not be terminated, and to allow the step parent to then finalize the adoption.
Okay.
And as I said, it's fairly rare, but once in a while it does happen.
Any thoughts on paraprofessionals doing the work as outlined?
So I asked Helen, who's been doing this for a very long time, what is the worst that can happen if we were, in a case where you give someone the ability to give legal advice, what's the worst that can happen? She couldn't come up with many examples, but she did say that if one person says that they did give notice to the biological parent but didn't, then that can be an issue, of course. But yeah.
Okay. Linda, did you have anything you want to ask, or do you feel like you have?
I just want to clarify, because I thought we had talked only about uncontested adoptions. And now it sounds like we're getting into the realm of the biological parent objecting to the termination of parental rights. So I just want to clarify what's contemplated by inclusion of step parent adoptions.
I think my threshold is no ICWA cases should be, and I think we have actually got that already in the family law, no ICWA issues to be resolved. And I would say any contested step parent adoptions.
What did we decide on the guardianships in terms of the threshold where paraprofessional representation stops?
I think
Because we did
I
talk
don't
about
know.
contested cases and where parents object and so on and so forth, but I don't remember where that conversation ended.
I think that probably should parallel the duties that we've given in the family law field in terms of they can help people prepare for hearings. They can do written discovery, exclude the depositions, exclude the expert witness discovery other than requesting a designation. That's what I would suggest.
Does the adoption process kind of follow the guardianship process where there's a court investigator's office, right, Judge? I mean, I don't do adoptions, so I don't know.
There is an independent report in dependency adoptions. It's obviously done by the agency. If it's an independent adoption, then there are agencies that do reports, or you can have the social worker do the report, but there does need to be a report of someone who's gone to the home, spoken with the prospective adoptive parents, prepared a report, giving some brief biographical information on the prospective parents. And so that needs to be filed with the petition.
Okay. So would it make sense to kind of make our recommendations similar to guardianships, for example? Guardianship of the person, because there's form intensive, adoptions are form intensive, guardianships are form intensive, there are independent reports being made. I don't have any stats, but it seems to me that most of these are uncontested. I don't have any stats anecdotally.
And
So,
in terms of guardianship, we pulled together this group of people to review the guardianship tasks. They developed the tasks, and I'm waiting to get back from them their recommendations on what should be included and excluded, and then I will share that with the group. But that hasn't been circulated yet, and I can go ahead and circulate the list prior to getting the recommendations. I just thought I would do it all at once.
well, that's fine. I'm just trying to sort of approach this from a consistency sort of
Right. Mm-hmm.
perspective. And if they're similar, then we should really follow the same format in terms of where we're going to recommend that paraprofessionals don't go beyond.
Right.
I think you are going to see a recommendation that the paraprofessional does not represent parties in contested guardianship and conservatorship matters.
Right.
I remember that one point that Judge Ebony made is that sometimes you don't know at the onset of the case whether it's going to be contested. And she called them pre-contested cases. I'm wondering if it's the same in the adoption realm, where maybe dad has been absentee and then you serve him notice, and then like maybe at a later point he tries to contest.
That's very rare. Again, I've had two occasions in 8 years where someone has come in and said, please stop the adoption.
Okay.
So for now, we're talking about these are only going to be the uncontested adoptions and no ICWA.
I would agree with that.
Uncontested step-parent adoptions.
Step-parent adoptions, yes. Right.
Okay.
And in general, for agency adoptions, so if it's through social services, they provide the representation that people need. So there's not a need, there's not a gap there. And the same, is that right?
They have a social worker that essentially the social worker, the PSW essentially staffs the adoption case. So
Okay.
they're the ones who kind of, will marshal it through the process. So I don't,
And for private agency adoptions, generally the parents have the resources to do this work. So we really are limiting this to uncontested step-parent adoptions.
But I just would say I did a step-parent adoption, and we did it, and the agency did do the report.
There are some counties that the agency will prepare the report, and I think Alameda County is one. San Francisco, interestingly, does very few, but they do not do them. but I think it varies from county to county.
Mm.
Yes, maybe we just say uncontested step-parent adoption, and we don't talk about whether the agency is involved or not, because it
Right.
differs. Yeah.
Okay. Okay.
And
So,
Linda, I'll email this to you.
thank you. I appreciate
Thank
that.
you.
So I think since we're still waiting for the recommendations, list and the breakout of the conservatorship and guardianship, as well as to get more information about these the non-DV violence prevention restraining orders, then I think that this, we can conclude early today. I do see we have a couple of, oh, sorry, Stephen. You're muted.
I need about 5 or 10 minutes to go over. I had met with the Family Law Executive Committee for CLA has got a subcommittee to deal with this. I met with them over the weekend. We had a few changes to propose. Some of it's just procedural, not even substantive, but if we could put up the family law list before we end, it won't take me long.
And the other thing that I want to do is, I see we have a couple of people members of the public. So I do want to provide an opportunity for comment just briefly before we turn to your list. So if either of the people who are attending want to make public comment, you can raise your hand. And I don't see any hands, so let me bring up, I have this document ready. Can you share that? Oops. And I will make it, let me just change the size so you can actually read it. Here, I can do it here. Oh, wait a minute, there we go.
Let me do view options. Okay. Scroll down to property. We had put discovery categories within property. The suggestion is we should probably have a separate category for discovery because it would apply even when there's not property issues. For example, we conduct discovery on custody issues all the time. So breaking out actually 4, 5, 6. Can you go down to the next page? 7, 8, and 9 into a separate discovery category.
Okay, so you want me to
Because this seems to suggest that they could do expert discovery or a deposition if it was only a child custody issue.
So you want me to just
Yes.
have discovery as a whole, and we'll put in 6.
Yeah. So it's
4 through 9.
Yeah, 4 through 9.
Oops. Okay. And in terms of the inclusion and exclusion.
Stays the same. No changes.
Okay. Huh.
To confirm, are we excluding motions to compel, motions to quash?
No, motions to compel and to quash were included. It was only motions related to depositions were excluded.
Thank you.
Any other changes?
Yeah, can you scroll back up? The quasi-community property would stay, but the inclusion of the nullity should come out, because that's actually referring to void or voidable actions, and the quasi-community property that arises from nullity was something we had excluded certain of those. I think that the word nullity created confusion for the committee.
Right, the property out of a nullity is called quasi-marital property.
Right. So if you could delete that out, because it created confusion for some of the people in the group. And
Yeah,
that was
and it shouldn't be included anyway.
yeah, and the footnote stays because the footnote had to do with the
Okay.
application we were expecting. Then where I think it's below where it talks about marital settlement agreements.
Mhm.
Yes.
Okay, a couple part of it's kind of a talking point. If maybe as a bullet point or sub point, if a paraprofessional is preparing a marital settlement agreement, it needs to be specifically recited in the MSA so a judge knows if that agreement includes elements it should not. For example, negotiation of termination of spousal support in a long-term marriage.
So maybe this should be a footnote?
Yeah,
You think?
well, I don't want to necessarily relegate it to, it could be a footnote, but in some way to communicate, they need to put, that needs to be a requirement that they include that disclosure. The second thing is when we do the legislation for the paraprofessional program, it may have to be a separate bill to specifically include a section that says that just because a paraprofessional overstepped their boundaries and an agreement got approved that included something that shouldn't have been in there, it doesn't make the MSA void or voidable. And that the judge has to kind of take a look at the agreement as a whole to see if it's unfair, kind of similar to the cases that talked about inadequate disclosures that came down in the last 5 to 10 years.
I'm sorry, I was busy doing this, so I didn't quite catch what you were saying.
Number two, put number 2 in it. Companion legislation stating that an MSA prepared by a paraprofessional, which exceeds the scope of their duties, is not automatically void or voidable.
Would that really go here as number 2?
Yeah, this is not really a task that they're doing.
No, it's a note
something-
for us to make sure that that gets done. Because can you?
Okay, so I'm just making a comment that this needs to be included in what we ask the rules and the the development of the.
Right.
Okay, so I'm gonna leave it here for now, and just add a comment that this.
But and footnotes will be fine. The reasoning being these two things need to be done in order for us to include the MSAs within the paraprofessionals scope
Okay.
of duties. Because if the paraprofessional didn't disclose their role, a judge could be approving a paraprofessional prepared MSA and not know that it exceeded the boundaries.
Got it. So I'll add that as a note. as
Okay.
another note.
Then the last thing I got from the group that doesn't require any change to this form is as I suspected, the Family Law Executive Committee's pretty adamant about they're not opposed to the paraprofessional being a support person, but even answering questions from the judge goes beyond, and I would expect them to oppose any legislation or proposal that states that a paraprofessional can be directly responding to the court. And I know that could be helpful to the court. These were the factors and issues that were brought up. Number one, the way you, and I mentioned this the other day, the way you answer a question can actually be argument. I know when I'm answering a question from the court, of course, I'm trying to argue or posture the answer and the best way to advocate for my client. Number two, a strong belief that while there would be judges that would respect that boundary, there would be others that would be hard pressed, would start morphing the paraprofessional into being the person that they're communicating with, and that would be an issue. And just third is that delineation between, look, if you want to be a lawyer, but if you want to be a paraprofessional, that's one of the few things that we want to preserve for the family law attorneys. And I would expect, like I said, I would expect them to oppose any proposal or any legislation that allowed a paraprofessional to participate in hearing. Now, again, we have always talked about this being a pilot program, family law being first, and it may be the case that recommendation changes, or after more family law attorneys have had experiences with paraprofessionals in court, that opposition would wane. But I know the knee-jerk reaction is going to be no. And the bottom is, there's so many attorneys right now that are not informed or aware of this working group or its activities, that there is going to be an automatic opposition once this actually comes out and is part of legislation. And I think getting the support of the Family Law Executive Committee and the Family Law Section for the California Lawyers Association with regards to the family law proposals would be really important.
Steve,
Yes.
what about, have you guys discussed a 6303 type of section that delineates what the paraprofessional can do inside the courtroom, at the same time limiting, putting in limitations? So the 6303 lays out what an advocate, DV advocate can do, which is pretty much silence, right?
Right.
But in an attempt to, and I agree, that we don't want them to, I agree that the paraprofessional should not represent as an attorney would, but what about a sort of a, kind of lay out in a code section what they can do? And that would provide clarity for judges, because I think right now when at least in our county, when a advocate steps out of their bounds, we just refer to 6303. We just refer to 6303, which is very helpful. Have you guys talked about that?
I think the language would be they could assist the client during the hearing. They can accompany them to counsel table, but they are not allowed to actively participate in the hearing.
Right. No direct communication with the court, but helping the client with tasks. Like if the judge, again, I don't litigate, but if a judge asks for an exhibit or something like that, the paraprofessional could kind of pull that out and give it to them or something like that, right?
Right.
They could have a little bit of a communication in the ear, or don't forget to ask for support or something like that. Would that be possible? Would that be something that your group would?
Say that one more.
So for example, right now a DV advocate under 6303 cannot say anything. So if a lot of times what we see with protected person, they forget to ask for something that they'd asked for in their paperwork, and it just gets overlooked, right? Attorney's fees or a child support or something like that. And a lot of times the details of something, like if a child support is ordered, there's sometimes no commencement date or no payment on arrears or something like that. So that DV advocate cannot fulfill that role, cannot remind the person. So I want to know if a paraprofessional could do that, kind of whisper in the client's ear, hey, you forgot to ask for,
Yes.
child support.
They absolutely could prompt their client to say, look, you needed these. Like I would expect a paraprofessional that's going to sit at counsel table, they should have their checklist of what the orders are that they want, right? And literally check them off as they come, and then be able to prompt their client, but not be able to directly say to the judge, hey, judge, what about the commencement date? Or hey, judge, we just put it 1:15.
Not directly to the judge, but just have it checked. That is tremendous help. That is, far and beyond anything that's happening right now. And I think if we can't go full representation, I think this is tremendous. Plus, they're sitting right there. They can hear the court's orders themselves and prepare that order much faster, than that is happening right now. In our court, we prepared for SROs. But anyway, I think that really goes far. And if we cannot, if there's no consensus on representation, and there is no representation, if we could have a code section that kind of list what they can do and fulfill those roles, I think we've come a long
They
way.
can advise and counsel the client during the hearing and assist the client in responding to inquiries from the court. It's kind of what I'm thinking. And, you know, I was really happy because I think I articulated for this group last week, you know, I was concerned that the list that Fariba and I had started with and has morphed into what we have on the screen right now, that I hadn't talked to my constituency, and I was worried that we had gone, because we've got a lot of different functions and activities a paraprofessional would do here. And I was really pleased that the subcommittee that I met with, they did not, other than the clarifications I gave you, they weren't opposed to any of these recommendations. So to me, I thought that was very forward thinking on their part. And I think they appreciate and understand this is going to happen, and to work with the bar to create as expansive as possible without blurring that line between a paraprofessional and a lawyer.
Linda, can you pull up the in-court representation recommendation that this group did come up with?
Yes, hold on a second.
Man, it's cold.
Hold on. All right. So can you see that? And I think we're calling it not in-court representation, but in-court support is what was decided.
So Stephen, this is consistent, right?
Yes, it is. And I just didn't remember this, but I did want to talk to them too. They were supportive of the paraprofessional being able to sit at council table and not creating this, you know, ridiculous, you know, comic of someone having to walk back and forth with the audience to talk to their paraprofessional. Because really too, because the paraprofessional can then have everything laid out. They can work out arguments. They can make sure the exhibits are ready. Because that's one of the skills that you just get over, you know, time as being an advocate, that they're going to be able to build up that skill and dramatically help previously self-represented parties in presenting cohesive admissible evidence to the court.
And I don't think it should be blanket not speak. I think not speak directly to the court. And may advise the client, not necessarily how to respond, but in general. I think, Steve, you put it a certain way. I forget what you just said.
I think put in another
May prompt the client, yeah.
Correct. May prompt client regarding, I don't even know.
It could be everything. It's not
Right.
just how to
I don't
respond.
think just may prompt client.
Yeah.
Okay. And I think we talked about actually taking out this C, because the court has that discretion generally, and we didn't, I think there was some concern about
Heavy-handed.
About it being heavy-handed and kind of giving broad authority than the court just inherently has.
Yeah, because a court can remove me if I start going, you know, a few good men in the courtroom and getting outrageous.
Right.
I can be taken out. You take me out, Judge Wiley.
In a heartbeat, Mr. Hamilton.
I think
And
I
I
think
think there
we
was
put
some,
it in there because 6303E has that for DV support people,
That-
but
That's why we did it, but with the,
yeah.
but remember, the DV supports person is just to be there for support. They're not supposed to be steering the litigation, right?
Right, and they're not always professionals. They could be a friend or relative, so they
Correct.
don't often know how to behave.
Yeah, I'm perfectly fine with that.
I agree.
It's
Yeah.
just taking it out. Yeah.
Yeah.
Okay.
Yeah,
Alright.
if this gets adopted, like, so, and I would say the task list is not independent of this issue. In other words, if the vote is to allow in-court rep, either answering questions or participating in the hearing, I would expect my constituency to argue against a retraction of the duties to make them more narrow. But by then it'll be in the legislative state, it'll be out of our hands. But that's what I would expect. I think their willingness to make the list so expansive is tied to this creating this clear differentiation. The one clear differentiation is that role in the courtroom. So
This makes sense to me.
All right.
appreciate that.
Thanks.
So thank you. I know we were
Anything else?
20 minutes ago, but I appreciate that.
No, this is great. And I jumped the gun on that because I should have invited you to report back on your meeting with this subcommittee.
Oh yeah, and thanks for giving me the task list too. That helped a lot because I sent it to them and then everybody went through it and I was really pleased. Like I said, there wasn't this knee-jerk backlash reaction. They can't do this. They understood, and they are supportive. There was a couple issues that I think Steve Fleischman has brought up where number one was the fee limits. I've talked to CLA. There was a CLA meeting last week, and somebody from the intellectual property or one of the other subsections was saying, you can't put a fee restriction on a paraprofessional. That's going to get overturned. So we're not supportive of fee limitations, nor is the section supportive of a monetary limit on property issues. Because what do you do if somebody's got $1 million in assets, but $1 million in debts? Does that mean it's zero? And so they can work on it or not? It just creates too much confusion and probably would be an inappropriate restraint on trade.
Great.
So,
Great, thank you.
Anything else from anyone? Okay, great. Well, I hope at our next meeting, I hope to have a lot more information on these other topics that I will send to you in advance of the meeting. Okay.
So we just have the conservatorship guardianship one left, right?
And the violence prevention.
Right.
So the elder abuse, civil harassment, and workplace violence.
And maybe gun violence restraining order, yeah?
I don't think that was on our list.
It
No.
wasn't.
Okay. Well, there are not a lot of private people who apply for that anyway, but it's usually law enforcement.
Well, thank you.
All right, thank you.
Thanks, everybody.
Thanks,
Bye.
everyone.
Bye, everyone.
Goodbye.